law, governance and leadership with workshops and training, property law, wills, trust and estate planning. For more information, contact AL Inc. on WhatsApp 065 844 347 or email hello@al-inc.co.za. AL Inc., your ally.
Come on out.
What a time it is to be alive indeed. 16 minutes after 5 o'clock. It's the third and final hour of the program. And of course, we are live on Facebook and YouTube as of now. You heard the sounds of Worship House Africa for Jesus. Ahead of that, live in Caps, Praise a Sea Weapon. Now, as we always say, this program has everything. There's encouragement, there's amazing music, there's interaction, and then, of course, there's also the informative conversations. Now, as you know, we started a brand new segment last week, All Things Legal with AL Incorporated. Now, over the next 3 months, we're going to be talking, or rather unpacking key legal topics that may affect your everyday life. Now, from wills, trust, even to property law, as well as employment rights and governance, and so much more. There's a plethora of topics that we are going to uncover. And as mentioned, AL Incorporated is a wholly black owned law firm based in the Western Cape, launched just before South Africa's national lockdown in 2020. Through strategy, perseverance, and adaptability, they've grown into a trusted legal partner, providing efficient, affordable, and high quality legal services to individuals and businesses alike. And so we did, of course, have the context, and Alayna shared the backstory through all of that last week. If you missed it, as always, have a look at our Facebook and YouTube pages. That's, of course, CCFM 107.5. In fact, we are live right now. So hello to you and yours. You can check us out and leave a comment. Alayna?
Yes.
Hi. Happy Tuesday. How has it been on your end?
It's been good. I think, when I got in here, you asked me how am I doing, and I said, well, it feels as though last week spilled into this week, and but we roll with the punches.
Yeah.
It's I think part of living. You go forward, ups and downs. So, but I'm good.
The show must go on.
100%.
Alayna, it's the second segment. Now, of course, we set the tone last week in terms of what we can expect, who AL Incorporated is, and we're excited to venture in these next 3 months. Now, we spoke off air, and the statistics are shocking. Okay, now, and you will share on this,
Yes.
but 15%, it seems, or rather it is that 15% of South Africans have wills that are in place. The remainder, 85%, are sitting without wills. Now, again, this is really shocking. But before we even touch on why that is, I wanna talk about a will, what a valid will is, what it looks like, and also why should I have a will?
All right. A valid will is or the requirements rather for a valid will is delineated in the Wills Act.
Yeah.
So we have a piece of legislation that governs the distribution of the assets of a deceased person. It's not the only piece of legislation that governs what happens to the estate of a deceased person. There's others. It's an array of different legislations, really. But Wills Act 7 of 1955 is what governs the requirements for a valid will, which is what we'll be discussing today. And what that looks like is first and foremost, it's one of the documents in one's lifetime that has to be in writing
Mhm.
to be valid.
Mhm.
So it doesn't have to be typed out. It can be written, but as long as it's on paper and there's a tangible document that reflects the
Yeah.
testator's wishes, is one of the requirements for a valid will. The person who writes the will must be of the age of 16 years old in order to write out a will.
Yeah.
And if that individual has properties that it specifically wants to bequeath to another person, then it's probably a good idea to write out a will. A valid will also requires 2 witnesses to attest to that will. That witnesses must be competent individuals,
Yeah.
and competency is tested by age in South Africa. So you are a competent witness if you are 14 years of age. And then every page that is written out, if your will has more than 1 page, each of that pages have to be signed by the testator as well as the witnesses present.
Mm.
And then that's basically what qualifies a valid will.
Yeah.
Of course, the request that's made by the testator, and the testator, just for information purposes, is the person writing the will. So
Right.
that's a word you'll probably use. We'll probably be talking a lot about. The testator will cannot bequeath something that's not legally permitted by law.
Right.
So as long as your bequest is legal, it is not prohibited by law, there is nothing that you can't, announce in your written document that gives effect to your wishes, essentially.
Yeah.
Yeah, I think that answers your question.
Yeah.
It's, I mean, anybody with those requirements could essentially draft a will.
And just on that
yeah.
note, Alayna, you're saying anybody, but I know that there are certain misconceptions.
Mhm.
And one common one that I've heard over and over again is that one needs to have a certain amount of wealth, for instance, before they write a will, or they must have X amount of assets before they have a will. So let's just maybe debunk some of these misconceptions.
I think the person that, well, the question really is there something that you own that
Yeah.
you'd like to bequeath to a specific individual?
Mhm.
If that is the case, then by all means write it down and give effect to your will. I think the misconception comes in when, because people have this idea that, it is costly
Right.
to administer a will, but there are certain limitations that legislation provides for that. So if your will, for example, the value of your assets exceed a certain amount of money,
Yeah.
250,000, you don't have to register your will at the master's office.
Ah.
And the requirements for registration, or the requirements to give effect to the winding up of your estate, is significantly reduced
Oh wow.
based on based on the value of the estate. And so there's lots of checks and balances, and I think because people don't know that, they sort of just lean into other people's experiences without really understanding that there's unique requirements or
Yeah.
unique circumstances to every individual's estate.
Mm.
So if your estate exceeds 250,000, then you must lodge the estate with the master's office. But I think those conversations we're probably going to have a bit
Yes.
later when we have a discussion around the administration of estates, and that is another piece of legislation that
own,
will
yeah.
canvass, as and when we have the opportunity to do so.
Yeah. But I think what I love about this is that such opportunities and such platforms, and perhaps you now know more than you did before this conversation started. And so, as I've mentioned, this will be an ongoing feature for the next 3 months, where we will be unpacking key legal topics. Today in particular, we're touching on wills, and the conversation will follow up until next week, because there's just so much to get into, and giving you a moment to think about it as well. Do you have a will in place? Does your family member or members have wills that have been put in place? Please also visit us on Facebook as well as YouTube. We are live. I'm chatting to the managing director, Alayna Levendahl, of AL Incorporated. Now, I want to talk about the key legal requirements, Alayna. What is that for a valid will? I know we briefly touched on it, but for someone who's going, hold on, I can actually just draft a will tonight after listening to this conversation.
I'll just canvass it again quickly. it must be in writing.
Yeah.
We spoke. It must be written by a testator that
Yeah.
is of the age of 16 years old. It must be signed by all the parties, the testator, the witnesses, and it must be signed in the presence of each other. The witnesses must be at the age of 14 years or older. And if it has multiple pages, everyone must sign those pages as well. And yeah, that's basically the essential requirements of a will. I think just to touch on your first question is like, why would people why would people need a will? And my question probably is to that question. It's like, why not? It gives you peace of mind as to what would happen with your assets, when you are no longer there.
Right.
It is a document that basically gives effect to your wishes. And outside of that document, the legislation is going to choose for you. I mean, if you have a child, for example, you'd want to nominate a guardian in your will. At least it gives guidance to the parties or the survivors that you leave behind. So yeah, my question is, why not? Why wouldn't you?
Yeah. And then something else that is maybe common is errors and mistakes. What are some of the mistakes that we commonly make when it comes to even drafting a will?
I think it's probably the most common is everything that we have mentioned that gives effect to a valid will.
Right.
So if you don't sign all of the documents, it's de facto, it is not a valid will. But the legislation, the Wills Act, also provides for sort of a catchment area or a rescue clause. That's Section 2, just for your information. But it deals with if the party or the beneficiaries or the survivors, is of the view that this will is valid. This will is the will and testament of the deceased person, then they can make a case for it. They can make a case to the masters of the High Court, and they can state, their case. This is why we believe that, it is the testator's wishes. This document is, for all intents and purposes, the testator's wishes. And one of the reasons could be that, well, the witnesses were present, even though they didn't sign it, they were present. So, they can attest to it is the testator's wishes, or there's at least a document in writing.
Right.
Perhaps the testator didn't sign the document. Perhaps there wasn't any witnesses present, but there's a clear indication that this document represents the wishes of the testator. And, things that could corroborate that version is, the testator made a video, stating the same thing. The testator spoke to very different people about the same things that's in the will. So there is opportunity after the fact, yes, to remedy it, but it does place significant amount of pressure on the executor of that will, or the person that you instruct in your will to administer the wishes, which is never a good thing, because dealing with the master's office is strenuous enough. Even if you're an attorney, it is strenuous enough. So you don't want to get into that situation where you are not drafting something that is de facto valid.
Right.
And there's no reason to not do that, because shows like that the information around wills is so easily accessible. And this is a good platform to just engage and ask questions and make sure that you are in a place and space where you don't have an invalid will.
Yeah, absolutely. And so on that note, we also just want to throw it out there that we will have a will day at Radio CCFM, but we're going to get into that in a bit just before we wrap up the conversation. Questions, comments, please send it through to 061 798 1075. I've got a couple that came through here from Anonymous. Anonymous's daughter bought a flat cash. She's single, no kids. Does she have to have a will?
Yes, I think so. Your daughter in that instance would have to nominate who her desired beneficiary would be. Who would get that property. perhaps in this instance, if it's a good relationship between the parent and the child exists, then, by all means,
Yeah.
the intestate succession would say that it would go to the parents, if the person doesn't have any descendants. Then the parents is the next line of beneficiaries
Yeah.
in terms of intestate succession when you die without a will. But that's not always the case.
Yeah.
You could be in that's not always the case, and everyone's scenarios are completely different.
Yeah.
So you may not want to bequeath or leave that property to your parents.
It's interesting.
Yeah.
Very interesting. We are live on Facebook as well as YouTube. I think I'm going to take 2 more questions before I continue with the conversation. I'm chatting to Alayna Leovendal, who's the managing director at Al Incorporated. We're talking all things wills, and in a bit we're going to talk about what happens if you don't have a will, and anything else that we don't get to, of course, we will proceed to next week. This one is a message saying, good afternoon, may I ask, if you should divorce and both parties agree for a divorce and agree the one takes the house and the other party keeps his or her provident fund, would that be considered valid?
I just have to digest that question, or let's park it for a bit later.
Okay.
Because it is a depends type of answer.
We'll get back to that one.
Yeah.
Okay. This one says the following: what is the testamentary trust fee, or what is the cost of fees in general to wind up an estate? Please and thank you.
So the administration of estates deals with all of the fees applicable to winding up an estate. One of the major costs is your executor fees. So your executor can charge up to 3.5% of the value of the estate. So that is something to consider when you nominate an executor, but it's the maximum value. There's no reason that a testator can't negotiate the executor's fees to a lower percentage.
Right.
But it is important to take consideration or give consideration to the fact that there's a lot of work involved in administering the estate. There's the other costs to consider is the transfer costs of the immovable property. An estate does attract tax as well. So, but it only if it goes above a certain threshold, which is something we're going to discuss in more depth. I think it is next week when we dig into the Administration of Estates Act. We'll probably canvass a lot more of the cost implications as far as an estate is concerned. But I mean, there's the other cost is the advertisement cost, because once you draft your liquidation and distribution account, you have to let it lie for a month to call on all creditors. So there's a lot of small costs, and then there's also a master's cost that we will discuss. And so there is a lot of cost apart from the executive fees, and it really will depend on how big your estate is. If it's a small estate, it might not even attract tax. And it really is a depend kind of answer. And I think we'll dig more, we'll do a deep dive when we actually discuss the estate. I hope that answers the question, even though it's a very depend kind of response.
I think even the executor, that also will be spoken into next week, how to choose one, the intentionality behind choosing one. And so Denver Dreya's question leads to my next sort of question as well. Denver wants to know what happens to the property should there be no will. And I'm going to tie it in with this closing, well, almost closing question, Alayna. Should I find myself in a position where my family member has passed away without a will, how then will the state distribute their assets, and how does this impact my family? Because now the family is left in limbo. We don't know what to do. What does that look like? What is the solution there?
Well, in the event that someone passes without a will, the Intestate Succession Act will kick in, and the Intestate Succession Act makes provision for almost every scenario when it comes to the distribution of your estate. So you no longer as a testator, have a choice in
Yeah.
terms of how your property is administered. Legislation now does it for you.
Ah.
Whether or not you have a good relationship with your family, whether or not you're in a long-term relationship, you know,
Yeah.
and you actually wanted to marry the person, you're at the edge of marriage,
Yeah.
it no longer matters because the legislation will decide that for you. Which is why we encourage
Yeah.
people to take control of their own property
Yeah.
and their own wishes. And you can only really do that if you draft a valid will.
Yeah.
And we've already canvassed what the requirements are. So that's really my answer, without getting into the scenarios,
Yeah.
you know. But the Intestate Succession Act will govern then the distribution of your estate.
And so, Denver, I hope that also kind of answers your question. But I see that time is against us. As we mentioned in the beginning, that this is a very it's a big conversation, and so anything that we don't cover, we will of course cover next week, as well as I think it was Christina's question. I don't know if you want to answer that now, or we'd rather maybe answer next week or answer privately. What are you comfortable with?
Christina, I'm going to answer your question privately. One, it isn't very specifically to the topic we're discussing now because it involves presumably involves a divorce.
Yeah.
So I will have that discussion with you off air. I'm happy to have that interaction with you to answer your question, but maybe not now, not in this platform.
Fantastic. Before we say goodbye, Alayna, I alluded to this very quickly. We will, of course, have a part 2 and continue this conversation in depth next week. So please be sure to connect with us. Same time, same place next week, Tuesday. We will be having a will day at Radio CCFM. Now, I know we don't have all the details yet, but one thing is for sure, and we spoke about what listeners can do to book a consultation should they want to attend this World Day at CCFM. What does that look like?
Okay, well, booking is not open yet. Bookings will open up on the 25th of March. After that, the show of on the 25th of March, 2025. The requirements to participate in, the free wills drafting session or free consultation and drafting of the will session would be that you'd have to like our social media pages. So that would be our LinkedIn page as well as our Facebook page. And then you'll have to use our WhatsApp as a platform to engage us or to book at least your session. And yeah, that's basically it.
So just so our listeners understand, after the 25th of March, they can go to all your social media pages. They can they can follow, and then they book for consultation.
Yes.
Okay.
So between now and then, they're welcome to like our pages. Yeah.
Just
They
wanted
don't
to
have
clarify
wait,
that.
but they can only book after the 25th of March, because then we would have covered most, if not all, of the topics around wills, estates, and trusts, because we're using this month to just unpack that discussion, right? And I think they'd know a lot more, be more informed, as to what to do, what they'd like to do with their assets, and they'd also probably be more than they'll be in a better position to decide that L Inc. is the nominated platform to at least help them get to that place. So, I mean, they don't have to engage us. We don't have to write your will. We're offering it, yes. But there's so many different service providers that they can seek help from. And we are honored. We'd be honored to help you. But I also think it's something so personal, that I think after the 25th of March, you'd know whether we are the service provider that you'd like to solicit to assist you and aid you.
And it would be an informed decision.
100%. Yes.
On that note, speaking about collaboration, perhaps someone wants to then reach out to you, Alayna, and they want to utilize your services very quickly. Where do they find you? How do they get a hold of L Inc. Just to be in touch with you?
All right. So our WhatsApp details is 065 844 347. So if you need to engage us on any topic, you're welcome to do so. Just pop us a WhatsApp message, and our WhatsApp or the person that is facilitating that process will engage you and let you know what we need from you. If not WhatsApp, you can also email us to hello at al-inc.co.za, and someone will be in touch.
Fantastic. There you have it. Time went so quickly, and I
Really?
feel like we needed to unpack so much more. But again, the beauty of this is that it is going to go on for the next 3 months. So all your questions, we see you, Anthea, we see you, Mary Ann April Bergman, saying she's so proud of you, Alayna. And all the other voice notes coming through, Yonita. We're going to try and get into that. If we don't answer it, we can always answer it next week. Alayna, thank you so much for your time.
Thank you, Natasha, for having me.
And your insight. This was fantastic. On the way, we've got some traffic very quickly. And as mentioned, you can, of course, also have a look at our conversation. It is on Facebook as well as YouTube. If you want to repost, if you want to reshare, maybe you missed something while we were speaking, it is available for you to take and to utilize. As mentioned on the way, I've got a quick traffic update.